raise taxes every day.
Back to the open meetings thing. I'm on a notification list.
Right.
And
As a member of the press, you can be on a notification.
Do what?
I was just telling the audience that as a member of the press, you can be on a notification list for open meetings.
Well, can't just anybody be on the notification list?
I'm not sure.
Question.
Can you? But there is some distinction, maybe it's for special meetings or something, there's some distinction for press, I thought.
Well, it's,
In any event, go ahead.
well, I was pretty confident I was deliberately not notified. I've had quite a few interactions with these people, so I know if they don't tell me about a meeting, it was deliberate. And are there any ways to get any justice for that? I mean,
the question, that exact issue came up in that Democrat Gazette story that I told you about recently regarding the housing authority, the Little Rock Housing Authority. Ginny Monk is the reporter. You should look up her stories recently, last month. She talks about how she was on a list, she wasn't notified, the exact same type of thing. Now, if an open meeting fails to follow the Open Meetings Act, then any decision made in that meeting can be negated.
that was my
Yeah.
point.
I don't know whether...
Can I compel them to back up and have a do-over since they didn't notify?
I don't know whether... I don't think there's any opinion on it. So I don't know whether that would encompass the notification aspect of the Open Meetings Act.
If they continue to do that, though, they could be found criminally in violation and go to jail for it.
Absolutely. But remember, you've got to get a prosecutor to prosecute.
I think they have to, when they have a scheduled meeting, they have to give you at least a 2-hour notice to anybody that's on the list that he would be on.
Or emergency meeting.
If it's an emergency meeting,
That's a 2-hour notice on emergency.
Yeah, I think the 2 hours emergency, right, and then it's a longer...
it's at least 2 hours.
Yeah, it's long, yeah.
So for the employee evaluation, I guess exemption,
Right.
if a citizen were to make a complaint against a government employee, and then that complaint is investigated, is that investigation an evaluation record?
Yeah, not necessarily. It turns on some questions that I don't, it's in the book, not that I'm selling the book, but it's in the book. It's also in the Attorney General opinions. So I think the answer is it depends. It depends what happens with that investigation. Joe?
Right, I think it's part of it is if the way the exemption is read is actually kind of confusing. Because
It's very confusing the way it's written.
Because it says something along the lines of if the person is actually, or the records can be released if after the suspension or termination hearing, the person is actually suspended or terminated.
Yeah, if you get fired, then you can, if the employee gets fired, you can get more access to evaluation records relative to that fire.
Right, but the way the exemption is actually written, if there's no suspension or termination hearing, like if they just investigate it and find that it's invalid, then it kind of leaves you hanging as to whether or not the information should be released. I think it's 12B.
Yeah, no, I'm looking in the book.
And I made some very bad case law on that a couple of years ago. Basically, they said they didn't have to, I thought the burden of proof was going to be, or it's B12. I have it, but it's basically the Arkansas Court of Appeals said the burden was on the plaintiff, me, to show that record would be able to be FOIAable. That's exact opposite of what the actual statute says. If they didn't bring the record with them to court, then that was my first FOIA lawsuit I did, and then I was like, okay, I have to get them to actually bring the records I'm arguing against the courthouse. Otherwise, they can.
Yeah, let's see. I'm not going to read through the whole thing, but if I can see it quickly, I will see if I can read you from the book.